Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And as I shared with you guys in my last video, I'm going to be doing some videos over the weekend outlining the appeal for R. Kelly in the Eastern District of New York. The oral arguments will be taking place in the Second Circuit of the United States Courts of Appeals, I believe on Monday. I know I told you I was going to verify the date, but I believe it's Monday, and if it's not Monday, it will take place on Tuesday. So in this video, we are going to talk about jury selection and how they allowed people on the jury that had biases against Mr. Kelly. And I also want to point out that, I told you guys that the entire appeal packet is hundreds of pages long, and so you may have heard this information about the jury not only when I did the full appeal, which took about 4 hours, but also when Jennifer Bonjean had filed her appeal to Judge Donnelly. And so a lot of the content, instead of just rewriting the content, she pulled the motions that she wrote to Judge Donnelly, put them in this appeal, as well as some of the responses that the government gave to that initial appeal. And so when I'm reading the documents, it may talk about the prosecution and that type of thing. That's because she simply copied the information into the final appeal that she will be arguing this week. So let's get started. Because of extraordinary pretrial publicity, the district court directed the parties to submit a joint proposed jury questionnaire to be completed by prospective jurors. The parties reviewed the questionnaires to determine whether they could agree to the dismissal of some jurors for cause. The district court conducted an oral voir dire as to the remaining prospective jurors, affording the parties the opportunity to submit additional questions to probe their qualifications to serve as jurors. Numerous seated jurors were either familiar with accusations that defendant had a history of sexually abusing individuals, had previously faced legal problems, and or had seen the highly unflattering docuseries Surviving Lies, in which several government witnesses had appeared. Defense counsel did move to disqualify jurors who admitted they had prejudged defendant's guilt or had gathered knowledge about the case for other sources. Let's go into this. One, it says defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R. Kelly or were familiar with prior accusations of sexual abuse of minors against the defendant. Counsel's objectively unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial, in violation of defendant's due process guarantees. And voir dire is the process where, if you've ever been called on jury selection, remember, you go in, you sit in this room, and then they ask you some questions, and then they bring people in groups and ask some more questions, and then they narrow it down to a select group of people, who could potentially sit on the jury, and then the prosecution and the defense have the opportunity to ask you questions to see if you will be fair in hearing the case. And if they don't think you'll be fair, they do what's called a strike. And they get, depending on the type of trial, they can get like 3 to 6 strikes where they can say, okay, I don't want this person on the jury. Where leading up to Mr. Kelly's case, they had hundreds of people who were sent questionnaires. And then from those questionnaires, they got rid of hundreds of people. And then when it finally came down to jury selection, they had a set number of people. I don't want to throw numbers out there because I don't have the document here with me, but they had a set number of people that they were going to consider for the trial. And then they did their strikes, and they didn't even go through all the final people. because I reported to you guys, I believe they were down to like 50 people, and they were like, oh, you know, we should get through this by the end of the day. And then it was a couple of hours later, they said, okay, well, they've sat the jury. And so a lot of people, they didn't even get to go through the full process because they chose their 12 jurors and like 6 alternates and kept it moving. So we don't even know who those other people were that didn't even get through the final process. So in any event, it says the government defends trial counsel's performance during voir dire, claiming that defendants' complaints are vague and belied by the record. Specifically, the government vouches for counsel's performance, arguing that trial counsel actively participated in voir dire. The fact that defense counsel participated in voir dire does not mean that his performance was objectively reasonable, where he agreed to the seating of multiple jurors who, 1, had seen surviving R. Kelly, 2, were aware of defendant's reputation that he quote-unquote loves little girls, and 3, were familiar with his prior legal troubles, including his criminal prosecution for creating sexually explicit videos with a minor. Had there been even one juror who had seen surviving R. Kelly seated in defendant's jury, his jury could not be deemed impartial. Incredibly, defendant's jury was comprised of 2 people, jurors 3 and 5, who watched surviving R. Kelly, and numerous others who were fully aware of accusations against defendant for sexually abusing minors. Defendant contends that fully half of his jurors should have been disqualified for cause. The trial counsel did not move for any of them to be disqualified for cause and did exercise a preemptory challenges against them. And then there's a note at the bottom of the page. It says, undersigned counsel received the jury questionnaires from trial counsel. The questionnaires that form the basis of this claim should be filed on the docket under seal for use on appeal. So the government minimizes the extraordinary prejudice that defendants suffered when at least 2 seated jurors had watched SRK, or Surviving Lies as we call it over here. The government even claims that there was something strategic about trial counsel's decision to seat these jurors. The government is nothing short of absurd. The court need only watch the embedded sample clips of Surviving Lies to conclude that no possible trial strategy exists for failing to move to disqualify jurors 3 and 5 for cause. The government's efforts at constructing a trial strategy are unpersuasive. Surviving Lies is a docuseries consisting of 11 episodes that graphically detail claims of sexual abuse against the defendant by numerous women. Some of the information communicated in the docuseries was presented at defendant's trial, but much of it was not. Indeed, the docuseries highlights the stories of scores of women who claim to have been victims of sexual abuse and offers no countervailing viewpoint. A large part of the documentary details defendant's prior criminal case that involved allegations of abuse of a 14-year-old, which included allegations that he videotaped himself urinating on this person. It is nothing short of mind-blowing that defense counsel acquiesced to the seating of jurors who came to the case with this highly prejudicial information that no human being could have put aside. Trial counsel's decision to seat these jurors is particularly troublesome where there was simply no reason to do so. Although the documentary was popular, it would not have been difficult to impanel a jury that did not include individuals who had seen the docuseries. Moreover, there is little doubt that the court would have granted defense counsel's motion for cause to disqualify any jurors who had seen the docuseries or were familiar with his prior criminal prosecution, probably with no objection from the government had defense counsel simply asked. And then there are notes on the previous page, so they include three YouTube videos, I'm assuming, that have to do with Surviving Lies. And then it says in the third note, Surviving Lies can be live streamed on several platforms, including Netflix and Amazon Prime. Defendant is unable to attach the docuseries to this pleading without violating copyright laws, but refers this court to the docuseries and relies on the full docuseries in support of this claim. The YouTube links provided in footnote 1 is a small fraction of the type of information at least 2 jurors possessed prior to being seated as jurors. So, I guess I have to go back and look at those and see what that is. So it goes on to say, defendant contends that counsel's on-the-record performance is objectively unreasonable where no possible trial strategy exists for loading the jury up with people who are exposed to undeniably prejudicial bad act evidence, much of which would not have been admissible at trial. To the extent the government contends that the defendant himself agreed to seating these jurors, it is dead wrong. As set forth in the attached declaration, defendant was provided no opportunity to review the juror questionnaires prior to trial and consider himself a bystander during this critical stage at trial. Defendant explains that he played no meaningful role in the jury selection process and that when he attempted to assert himself and express his concerns about jurors who had watched the docuseries, his concerns were dismissed. Indeed, defendant had no idea that at least 2 jurors who decided his guilt had watched the documentary. Defendant declares that he did not consent to the seating of jurors who saw surviving lies or those who had knowledge about prior allegations of sexual abuse against him. The government argues that defendant cannot demonstrate prejudice because he cannot show that any juror had actual bias. The government does not pass the laugh test. Right, Jennifer. Does not pass the laugh test. According to the government, actual bias is bias in fact, the existence of a state of mind that leads to an inference that the person will not act with entire impartiality. This record demonstrates that before stepping into the courtroom, 2 jurors heard over 360 minutes of victim testimonies, including graphic accounts of urinating on 14-year-olds. If this type of information does not lead to the inference that a person would not and cannot act with impartiality, it is difficult to imagine what would. And then I'm going to go back up here because there was a note. It says, jury selection is a critical stage of trial, and that came from Gomez versus United States, which was a case that was heard in 1989. So it says a whopping 6 jurors were familiar with allegations that defendant had previously abused minors and had faced legal consequences for such conduct. The government attempts to trivialize the prejudice to defendant, but it is simply beyond debate that defendant's jurors suffered from actual bias. Frankly, even if defendant cannot show actual bias, bias should be presumed here. The United States Supreme Court has observed a fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of cases, but our system of laws has always endeavored to prevent even the probability of unfairness. To perform this high function in the best way, justice must satisfy the appearance of justice. And that was a 1965 case, Estes versus Texas. And then it says, as Chief Justice Taft said in Turney versus Ohio in 1927, the requirement of due process of law in judicial procedures is not satisfied by the argument that men of the highest honor and the greatest self-sacrifice could carry it on without danger of injustice. Every procedure which would offer a possible temptation to the average man to forget the burden of proof required to convict the defendant, of which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. And once again, that was from Chief Justice Taft in the case Turney versus Ohio from 1927. So it goes on to say, Bonjean goes on to say, indeed, the United States Supreme Court has struck down convictions irrespective of a showing of actual bias
with prejudice is inherent in those convictions. And then she cites Redu versus Louisiana and Turner versus Louisiana, and those were cases from 1963 and 1965. This is a case where prejudice is inherent in defendant's convictions because fully half of his jury was exposed to highly prejudicial and inadmissible evidence that invariably interfered with defendant's cherished constitutional safeguards. In the old but highly instructive case of Marshall versus United States from 1959, the United States Supreme Court reversed a defendant's drug conviction after concluding that exposure of some of the jurors to newspaper articles was so prejudicial to justify a new trial. During the defendant's trial, 2 newspaper articles got before a substantial number of jurors. The news accounts contained information that the defendant had 2 previous felony convictions and detailed the circumstances of prior arrests and convictions. Upon learning that the news accounts had reached the jurors, the trial judge questioned the jurors about whether they had seen the articles. 7 of the jurors had some exposure to the articles, but all assured the trial judge that they would not be influenced by the news articles and could decide the case on the evidence in the record. The trial judge denied the defendant's motion for a mistrial, finding that there was no prejudice to the defendant. The United States Supreme Court reversed, finding, quote, "We have here the exposure of jurors to information of a character which the trial judge ruled was so prejudicial it could not be directly offered as evidence. The prejudice to the defendant is most certain to be as great when that evidence reaches the juror through news accounts as when it is part of the prosecution's evidence. It may indeed be greater, for it is then not tempered by protective procedures." And then she goes on to say, consistent with the teachings of Marshall, defendant is entitled to a new trial. Half of his jurors were exposed to information of a character that was so prejudicial that it could not be offered into evidence. Indeed, had trial counsel simply moved to disqualify these jurors, it seems likely that those motions for cause would have been allowed. Prejudice to the defendant must be presumed, even the inflammatory nature of the information that no average human could put aside. Defendant's convictions must be vacated and a new trial ordered. Then part 2. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government's witness, Azriel, that was imputed to the entire defense team. Defendant rests largely on his arguments contained in his opening memoranda of law. Defendant was denied his constitutional guarantee of conflict-free counsel when his attorney labored under a conflict of interest based on her simultaneous representation of defendant and government witness Azriel. Trial counsel further suffered from a Fulton conflict. Neither of these conflicts were waivable. In light of the foregoing, defendant's conviction must be vacated and a new trial ordered, and it was respectfully submitted by Jennifer Bonjean. And then the exhibit that she included was a declaration by Robert S. Kelly, and then I'm going to go through the points on this declaration. It says, number 1, I am the defendant in the above captioned matter. 2, I am making this declaration to provide additional facts about my participation in the jury selection process at my trial. 3, I did not participate in jury selection in any meaningful way. 4, I was not asked by my attorneys to offer any input about what types of questions should be included in the jury questionnaires that were submitted to potential jurors. 5, I also did not review any of the completed jury questionnaires with my attorneys prior to trial because of my limited literacy. I relied on my attorneys to review the questionnaires with me prior to trial, but that did not happen. 6. During the jury selection process, I did not participate in any sidebars related to questioning of jurors, and I was not asked my opinions about potential jurors. My lawyers picked my jury. I did not. 7. At certain points during jury selection, I did hear that some jurors may have seen the Surviving Lies docuseries, and that concerned me greatly. 8. I raised my concerns with my attorneys, but they shooed me off. I was nothing more than a bystander in the process. 9. I did not know that some of my jurors had seen the docuseries Surviving Lies. I also did not know that some of my jurors were familiar with prior allegations against me, including my prior criminal proceedings in Illinois. Okay, hold on. Let me go back up here. At certain points during jury selection, I did hear that some jurors may have seen Surviving Lies, and that concerned him. But then he turns around in number 9 and says, I did not know that some of my jurors had seen the docuseries. I also did not know some of my jurors were familiar. Okay, so he had heard rumors, but he didn't know that these people had actually made it onto the juror. Okay, that's how I'm taking that. Okay, 10. Had I known the information, I would have challenged those jurors as unqualified. I also would have told my attorneys to strike the jurors. 11. I did not consent to any jurors sitting on my jury who had knowledge and familiarity with the intimate details of my case or who had watched the Surviving Lies docuseries. 12. There was no strategy involved in choosing the jurors that sat on my jury as far as I could tell. At least there was no trial strategy that involved my input, and that was signed by Mr. Kelly himself on April 4th, 2022, which was yesterday. Okay, so this was Jennifer Bonjean's response to the government stating that he chose the jury, he was okay with the jury, and that the jury was reasonable, and she's saying no, he did not select this jury. This jury was selected by his attorneys who did not involve him in the process at all. And then in addition to that, and I'm not sure why she didn't include this, but I still go back to the fact that this so-called anonymous jury and the timing of the change in attorneys really hindered the defense from investigating these jurors. Because, as I've stated numerous times before, but for people who may be new to my videos, when a case like this happens, the jury process is a serious thing. And now with social media, the defense can actually hire investigators. They can do forensics people who basically can take your name and Google everything about you. They can find out your social media. They can go through your social media and see if you made any statements that would indicate that you would not be fair and impartial to the defendant in the case. They have investigators that will go and talk to your neighbors to find out what type of person you are. They will try and talk to your coworkers, your friends, to find out what type of person you are. And in a case this big, they should have had like a mock trial. And the mock trial, basically, they bring in people, like a fake jury. And I've actually been called, not called for, but they send you a letter and ask you if you would like to be a part of the mock trial. And I believe it was the Pelican Brief, the movie The Pelican Brief with Julia Roberts and Denzel Washington. It was based on a novel by John Grisham, where they actually put on the mock trial so you can see, what it looks like. And then also, if you guys watch the show Power that comes on Stars, it's 50 Cent show, where they actually did a mock trial where they bring in these people to see, like, if they were actually on the jury, how they would receive the defendant, how the defendant got up and testified, would they believe the defendant, and they give them information about the case. And so he didn't get the opportunity to do any of this because, one, he had limited resources, financial resources, and two, past and current counsel just were not up to par, and like they didn't understand the severity of this, or either they just knew this was not a winnable case in the current form, and so they just did the bare minimum, hoping that it would lead to an appeals, like where they tried to set up for an appeal versus trying to actually fight for him and get a not guilty verdict. It was very confusing and perplexing.
Okay guys, that's it for this video. I haven't decided what I will cover in the next video, but I will be working on it after I finish this one. So expect to see a new video coming up in a couple of hours. And in the meantime, go ahead, rate the video, share the video, subscribe to the channel if you haven't done so already. And as always, please leave a comment, because that boosts engagement so that more people can be aware of what's going on and get the actual facts about what took place in this case. Okay, talk to you later. Bye-bye.